Thank you. Thanks a lot for inviting me. The pleasure is all mine. It was a fascinating presentation already. Thank you, Mrs. Rodriguez, as well. I'm particularly well, positively surprised and really excited to hear about this concept of platforms being private legal systems. That's really a point of view that I haven't heard very often yet in political debate, and I think it's a fascinating approach. And the question I was asking myself first when I heard about this private legal system idea is that does that mean that if we acknowledge that platforms are private legal systems indeed, does that mean that we should aim at regulating platforms as if they were private legal systems, as if they were kind of private mini states, or in the example of Facebook, maybe not so mini anymore? And I think this question, I think, is very relevant, and I'm going to come back to this during my presentation, because I think it forces us to consider and think about what platforms' incentives are and what they really are in real life, which is, well, big business, basically. So the question I would like to ask is, if you said platforms are trying to generate trust, is that really the case in most of those cases? If they, we say they're trying to gather communities, is that really what they are doing, or isn't their business model actually forcing them to do something else? It's all about, as you know, the business model is around advertisement and the collection of personal data of everybody. So I think these are really relevant questions to ask. I'm very happy to come back to those in our discussion as well. Now, I'd like to cover the question whether the Digital Services Act is an opportunity not to be missed, or whether it's an opportunity we should maybe miss. And I'm just going to go to those slides here. And first, I'd like to start a discussion about what the problem is that the Digital Services Act says it. The Commission says the DSA should tackle. And parts has, Mr. Rodriguez has already covered parts of this when she spoke about the intermediate liability problem and the general monitoring obligation. And I think those are really, valid points. And I think it's kind of important to kind of revisit very quickly what, how we've gotten to the position, the point where we are right now in history. And I don't know, what age you are, but I still remember how, how the world looked like before the big platforms arrived, and very much, when the internet was first around in the 90s, it was a decentralized collection of digital services. And if I say decentralized, that means there were a lot of different offers out there, and they were all more or less equal and equally accessible. They were built on open standards and protocols such as HTTPS, such as TCP/IP. And others, of course, more older ones like FTP and so on. And a couple of them are, many of them are still around. Think of email, IMAP, SMTP, POP. So those things are still around, but they all have in common that they were openly standardized, and everybody could basically implement them and make themselves compatible with what was already out there. Access was mostly stationary, of course. It was very different from today. And there was a limitation. Some things were really worse back then. It was really expensive to access stuff. Websites couldn't be big because transferring data was expensive. A lot of people were excluded from the network because of access costs. But I think what is also interesting to remember is that the traditional business model of the early internet was a very well-known one, which is, I give you a service, you give me money for it. I provide you an email inbox, you pay me money on a monthly basis or something. So that was kind of the start of it all. And as you all know, this is not the case anymore. You just see that the arrow tabs on my keyboard don't work, so I need to click. So today, we already mentioned that. I think, Mr. Rodriguez, your analysis was totally correct to say today the internet has been dominated by these centralized platforms that have gathered almost state-like powers over our lives. Their terms and conditions have gotten almost a status of law for many people. There are many countries out there where access to Facebook, for example, or YouTube is cheap, and access to the rest of the internet is expensive. Because companies are literally subsidizing access to their own platforms and making access to the rest of the internet difficult. And so for many people in the world, especially in the developing world, Facebook and Instagram and YouTube, that's the internet. They don't know anything else. And so the other point that they have in common is that these platforms are built on proprietary services. So different from how the internet started, it's not open protocols anymore. But these are services that are deliberately built to be incompatible with competing services. And that is not a technical necessity, but this is done out of business calculus. Okay, so a company says, as soon as I have gathered enough users on my platform, I can close myself off from the rest of the internet, and prevent people, or at least discourage people from going away to somewhere else, because the longer they stay on my platform, the more advertisement they will see, the more I will make money. Okay, so that's the calculus of these closed up walled garden based platforms. And that companies go up to the point where you probably remember that. I don't really know if that's still the case, because it's a couple of years now that I've deleted my Facebook account. But back then when I had it, Facebook was basically giving you a warning window, a pop-up window that would, when you clicked on a link that would lead to somewhere outside of Facebook, that would warn you whether you really want to leave the safety of Facebook to that wild open internet. And so this is just to showcase the length to which these companies go to prevent you from leaving their walled gardens. And as I said, today, contrary to what we had in the beginning, the business model has changed from service for money to service for personal data. And often that's called free services, and that's obviously not true, but it does cause a number of, while this is really practical for billions of users, it also causes a lot of issues in terms of data protection, power shift, because knowledge is often gives you power, but it also causes legal problems. If you look at, and I don't know how many competition lawyers are in this group, I'm certainly not one of them, but as far as I understand, this really causes a problem for competition law as well, because traditionally competition law would look at consumer harm when they analyze whether or not a monopoly is actually acceptable or not, or a concentration of market power is acceptable or not. And this consumer harm was, mainly measured, or one of the most important aspects of how to measure consumer harm is prices. So they would look at if a monopoly would push up prices and therefore harm consumers. If products are for free, well, it's impossible to prove that consumer harm, and so competition authorities have had struggles in the past decade to go after companies, even if they have abused their monopoly position. This is slowly changing now. I think all of those who follow the competition law debate a little bit in Europe, especially in countries who are moving ahead like Germany or France, I think will know that there is a lot of movement in this field going on right now. So I think it's important to consider this fundamental change that has happened. And here I totally agree also with you, Ms. Rodriguez, that this also must lead to a change in the legal regime that we're seeing. The e-commerce directive from the 2000s, or it was negotiated in the end of the 1990s even, isn't really built for this kind of internet, and it should be updated. So what's wrong with those dominant platforms? I've already mentioned a couple of points why this poses problems, but there are also problems that go beyond purely economic issues that we're seeing. We're seeing problems, and that is particularly interesting for me as a person working for a human rights organization. We're seeing problems in terms of fundamental rights. So these companies, they basically gather the power to decide what people say and see online. And as I said, for many people, these platforms are the only bit of the internet that they see. And so again, they gather kind of state-like powers over the freedom of speech of billions of people across the globe. And if I may say so, they're not doing that very well in terms of regulating their sphere of influence. We have seen instances where the lack of content moderation of Facebook, for example, has led to widespread violence and even killings of minorities in Burma. And we've seen instances in which, obviously, the content moderation decisions of platforms have had impact on elections all over the world. And obviously, the tools that these platforms provide to everybody really who pays, they give others the possibility to influence the public opinion in ways that we have not known before, and also in opaque ways that we've not known before. Dominant platforms are a single point of failure. Because if a platform goes offline, then the whole ecosystem is gone. The whole public debate is gone. Basically, if a platform decides to shift their model, remove functions, add other functions. When Facebook, for example, and I'm coming back to Facebook as an example just because it's very handy, when they decided to prioritize individual content over press content, that changed the dynamics on the platform incredibly fast, with people struggling to adapt, especially independent journalists struggling to adapt, for whom platforms such as Facebook are one of the main channels to reach an audience today. But they're also a single point of failure for pressure by governments. And this is less of an issue, I guess, in democratic rule of law countries, but it is an issue in many, many countries around the world, where governments obviously then acquire the possibility to pressure a particular company to remove content or censor content or push up other content. I think more prominent examples are TikTok in China, but also, for example, and that's not a social media platform, but for example, the way that Apple acts in China and accepts the obligations that the Chinese government is putting on Apple in terms of censorship in their app store and other apps. I think that is quite striking. It also creates a monoculture of content moderation rules. We've already talked about the infamous terms and conditions. They are a big problem. They are quasi-law for many people, but there's only this one set of law for each market that we are seeing right now in those very concentrated markets like social media. And then obviously this means that that every user has to subject to those laws. There is not really a choice for users, and there's obviously no way of influencing those rules because social media platforms are far away from being democratic states. And that's a bad deal for users all in all, which is why I would make a strong case for the DSA to be a law which tries to change those fundamental pillars of how the platform economy works today. And I think this is probably one of the first and maybe also the biggest point of disagreement with what Ms. Rodriguez has had presented before, that I don't believe that the DSA would be particularly useful if it only focused on trying to go after content by, or basically forcing platforms to go after content in a different way by changing the liability regime. And I try to use the remaining minutes of my time to try to explain why I think that is. Before I then go, let me just see if that's the right side. Oh yeah, I wanted to quickly say, if we talk about dominant platforms, we mean really dominant. I don't know if this is actually readable on your screens, but this is the market share of the top 2 companies in each market. That is online search, digital advertising, mobile operating systems, and social media. And you can see that we really talk about very, very dominant companies here. So how why don't I think that changing the liability regime will really solve the issues that we've been discussing? That is because if the DSA was to hold companies liable for user-generated content, then the only rational business decision that these companies can possibly take is that they take stuff down if ever they're in doubt that something could be remotely illegal in any of the jurisdictions that this company is based in. So that would, in terms of the DSA, that would concern the 27 EU member states. They have very different, criminal law and other kind of rules on what is illegal to be said or not said. And so this would basically create a big incentive for companies to remove content that is then potentially not illegal, and basically stifling people's voices. especially fringe voices of the society. And what I think is worse is that this would basically cement this kind of state-like, it would be a recognition of the state-like status that platforms have right now. It would outsource the decision-making on what can and cannot be said, what is illegal and what isn't, to privatized companies whose business model is not to generate trust or gather communities, but whose business model is to sell as much advertisement to us as they can and use as much personal data about us that they can get their hands on. And I think that really would create an internet that is just as a bad deal as the one that we have today. So maybe one word on the monitoring obligation, the general monitoring obligation, because this is directly linked to it. I think it's important to remember that the general monitoring obligation is, at the moment, that's a prohibition of a general monitoring obligation. It is not the prohibition of general monitoring. And so, as you said, Ms. Rodriguez, yes, companies do monitor. That's a fundamental part of how their business model works, and that is also part of the problem, I would say, for many. But not all of the platforms monitor. And I would very much like to see an internet in which I would very much like the DSA to contribute to recreating an internet in which there are platforms that do not necessarily monitor. But by creating an obligation, a legal obligation, the state, the government would basically force every company out there to monitor, something that I don't think is good for users either. But I'm going to stop here talking about liability, because I would like to use the rest of my time to talk about how instead I think the DSA should approach the regulation of online platforms today. I fully agree on the needed updates for the definitions of what platforms are. I think that would be really crucial so that we get this right and see who should be included in any upcoming rules. This is just a quick summary of what I just said, basically. And the early approach was, and also I admit the early approach in my own organization, EDRI, was how do we best fight content that is potentially illegal or harmful potentially to some people, but not necessarily illegal. And all the thing about notice and action system, happy to discuss that as well. But what I think is more crucial for the DSA to achieve is that we help changing the business model that they're built on right now. I know that's a long shot, but at the moment, the EU is the only actor that can effectively regulate this online space, because the US is, what's happening over there, and other countries don't have the same power as the EU with this big single market has. And so what we would need is that we tackle ad-driven platforms that create a commercial incentive to favor divisive and scandalizing content, because that is at the moment what keeps people's attention on platforms. That's what makes you scroll down your timeline for hours and hours a week, and that contributes to the polarization of societies that we're seeing all across the democratic world, and which potentially also breaks our elections. What we need to tackle is the opaquely personalized platform advertisement, or platforms, not only advertisement, actually the personalization of content altogether, that enables anyone who puts money on boosting content on any of those platforms to manipulate the public debate, lead to disinformation, election interference by whoever pays most. So boosting content with money is a big issue. Advertisement is a big issue that is based on personalized data. And that is because you're basically preventing a functioning public debate by showing every single person or small groups of people different types of content. So nobody on participating in the public debate knows anymore what everybody else has been seeing as, let's say a message or an advertisement or whatever. And so how can we have a public debate about something if we don't know what the others have been seeing as arguments, for example, in an election campaign? And we need to tackle the walled gardens that make it practically impossible for people to escape an online environment that may be toxic for them, even though it may not be toxic for others, right? And this is important to recognize as well, that just because a particular piece of content can be, or an online environment can be harmful for someone, doesn't mean that it is harmful for everybody else. And so creating actual choice for people to go away from harassment and grooming and hate speech and other horrible stuff that's going on online platforms is really one of the key things I believe the DSA should achieve and can achieve. And here's how I believe how, and that's just one example that I'd like to bring up. And there are many others, of course. Here are a couple of examples that I've gathered. I don't think I have time to go through all of those, but I think you have the slides, so please look at them later, about how the business model of platforms contribute to spreading the very content that we try to prevent being spread. So I think what we need is, first of all, we need transparency. And that's, it can be an empty word, but it can also be a very strong word. I mean, if I say transparency, I mean transparency about what kind of content is shown, how the algorithm works that shows you particularly, some particular content, but not other content. Algorithms that distribute ads, for example, need to be transparent. Who paid for which ads? Facebook has tried to get better with that. Twitter has tried to get better with that. Twitter has even went as far as prohibiting political ads altogether because they saw that they can't really deal with this. So transparency, I think, is a crucial thing that the DSA should mandate. Limiting personalization is the second. I have mentioned personalization already before. And if I say limiting, I don't mean prohibiting, but I think giving people, like having an obligatory option for people to switch off personalization if they wish to, that I think would do a big step to allow people to choose themselves what they want to see and what they don't want to see. And the next thing I want to spend a little more time on interoperability, because I think this is one of the key pillars that would allow us to break open those walled gardens. So I'm just going to go one slide further to talk about interoperability. Interoperability basically means making it possible for you to talk to people on one platform, even though if you are not on that platform, but on a different one, okay? So the reason why most people are on Facebook today is not necessarily because Facebook is the best social network in the world that you could ever imagine, but because everybody else is on Facebook. The same is true for WhatsApp or Instagram or all the other dominant services. And so here's what Facebook wants you to think what Facebook does to help you to connect and share with the people in your life, right? Sounds great. Who would not want that? This is what Facebook actually is. Facebook isn't connecting you to other people. Facebook is connecting you to Facebook. And they're showing, and you only what is in their interest you see. And that's, what allows them to show you more advertisement. And I think this is important to recognize in this context. Now, interoperability, how would that look like? I mean, imagine there was a second Facebook, an alternative Facebook, a social network, which, could have better content moderation than Facebook, could have less harmful content on it. It could have better privacy protections. It could be a paid-for network without advertisement, for example. It could be everything you wish for, right? There is a market for this if people had the possibility to leave. And now interoperability would mean that if you were on this alternative network, you would still be possible to send messages to people on Facebook, or to invite them to events, or to see their timeline and to comment on their posts, even though you're not on that Facebook. Very much in the same way that you are capable of sending an email from a Gmail email account to a Hotmail email account or a Yahoo email account, even though those are two totally different companies, right? And that's because email is an interoperable protocol which is open and everybody can implement it. So it would be scandalous, right, if Google said, sorry, Gmail people, you can only send emails to other Gmail people because, we're a walled garden and we're the best email service in the world. If you want to talk to others, please open a Gmail account, for God's sake. Nobody would accept that, right? Because email has been around in that way for a long time. And the same is true for telephone lines, right? I mean, if you're with Vodafone and you can call people from your other telephone company, that's totally normal. It would be scandalous if that wasn't possible. That's what interoperability is doing. And interoperability not only works in between providers, as shown here with Gmail and Hotmail, it also works vertically. It could mean that you can use the app of your choice to access a given online service. You wouldn't have to use the official Twitter app to access Twitter or the official Facebook app to access Facebook. You can use something else. In fact, that's already kind of possible today. because smart developers have built alternative apps for these services, but they don't always work as well because the platforms are trying to make this hard to work well. Not because it's technically impossible, but they're deliberately preventing those apps from working well because it would be against their business interests. I try to cut this short because I think I'm running out of time, right? So that would be okay. Perfect. That's I think if interoperability was obligatory, and I think the DSA could do that, then we would create the possibility for alternative services to pop up. Well, they kind of already exist, but they would have the chance to actually compete because people would be able to move away to a different service and bring business somewhere else. Okay. But there, okay, so I think this is very much what I just said. So it would open up the walled gardens. It would create real choice for people by enabling competing digital services. It would make space for innovation because it would allow, new companies to build different ways of content moderation, maybe better privacy, maybe healthier business models, whatever you wish for. Again, this is also very much in line with what the European Commissioner Thierry Breton is always talking about when he says we need digital sovereignty. It would really open up the door also for European business. That's not something I particularly care about because I'm a human rights activist. I don't care about other businesses, but as long as that gives choice for people and better protection for people, I'm all in for it. And it would reduce the centralized power of today's dominant digital services, which would improve accountability. And that's an argument I think that's often forgotten. One of the reasons why it's so difficult to hold those companies accountable is not only because they're based in the US, but because they are so rich. They have so much money at their disposal that they can basically throw any amount of money at any problem, regulatory or otherwise, that comes at them, and basically buy their way out. And they've been doing that for a couple of years now with a lot of success. So if there is a company that emerges as a competitor, well, they just buy it off. Mergers are rarely, if ever, regulated properly. If there is a regulatory problem or if there's a court case, they basically buy a settlement that works really well in the US. And so this is the way that they have managed to solve these problems and avoid actual regulation in the past. And I believe that's something that the DSA could change. So that was interoperability. And then I think the other 2 points I think are easy to understand. I think we need redress mechanisms for users. I don't know if that was mentioned earlier, but I think the ability for people to complain about content moderation decisions by dominant platforms in an independent way. So not complain to Facebook about Facebook taking down some content, but complaining to an independent authority about it. I think that would be really crucial because obviously theoretically you can already do that today. You can go to court if Twitter takes down a tweet and say that's illegal, and then it isn't. You can go to court and sue Twitter. But I mean, who does that, right? The only people who are able to do that are maybe, law professors or journalists or politicians, people who are already, either have the knowledge to do something like that or have the resources to buy that knowledge. Normal people won't. And that's why redress mechanisms that are easily accessible for people, so in the dispute set mechanisms or something similar should be in the DSA, in my opinion. And strong enforcement. I think the best example for what happens with a great law with weak enforcement is GDPR. And I love the GDPR. It's a great law, but it's not enforced the way it should be. And so having a strong authority, either centralized on European level or decentralized, on member state level, is for me a precondition for the DSA being a success. They need to be followed up. There need to be real consequences for companies who don't respect the obligations that such a regulation, and I hope it's going to be a regulation, puts on them. I think I can only finish up with the goal that I think this DSA should pursue. It should help create an open internet that protects people's rights and provides them with real freedom of choice. And this is really just a repetition of what I said before. And I think for the DSA, that really means that rather trying to fight online content and try to kind of create a really detailed system of which piece of content has to be removed under which time frame by which platform and so on, I think lawmakers should really focus on fixing the structural problems that make today's online platforms toxic. Not for everybody, again, but for many, many people, particularly vulnerable groups, particularly fringe parts of society, voices that that are often not heard on the internet today, but they should be heard just as much as everybody else. And I'm very, very happy to be open for a discussion on this and to hear your views and also other opinions on this. Thanks a lot for your attention.